Hi, this is Brad Wiewel with the Wiewel Law Firm. We're here to talk about the Secure Act, and the Secure Act has been this cataclysmic change to the law when it comes to retirement accounts. I'm not going to talk in this video about the new age 72 to pull out required minimum distributions. I'm not going to talk about anything other than how the money comes out of a retirement account to the beneficiaries, which is going to be, again, a lot on you because you're going to need to know these rules so you can give your clients good advice. You've heard this already, so it's not going to sound new. Your beneficiaries, your clients' beneficiaries, unless they fall into one of 5 categories, is going to have to take the money out of the regular retirement account and out of the Roth in 10 years following the death of the loved one. Okay, 10 years, no more lifetime stretch out unless you fall into one of 5 categories. Let's talk about those categories. The first category is married. So your spouse can still get it. They can still do a rollover. They can still wait and take it later. They have all the options they had before the Secure Act was passed. One quick tip: don't do a quick rollover for a widow or a widower who's under 59 and a half without consulting their lawyer, at least their CPA. Because if they do a rollover, then they're under the rules where they can't pull money out penalty free until they're 59 and a half, and maybe they need money now to the retirement account, and if they didn't roll it, if they kept it in the name of the deceased, they can take distributions penalty free. So just a little tip: be careful about rollovers, slow down on rollovers until you've got some other counsel beyond you and your firm. People who can still do a stretch out fall into 2 categories. One are people with special needs, and one are people with irreversible illnesses. If they have a special need or an irreversible illness, which is defined by the law, they can do a stretch out. And that's nice. This is a big improvement for special need people, by the way. The old law was harsh when it came to taxing retirement accounts to special needs beneficiaries. The new law is much better. Congress got the word apparently. So a special needs beneficiary against somebody with irreversible illness will be able to take it out over their lifetime just like they had before. But when they die and it goes to somebody else, the person who gets it will have the 10-year deal. All right? Don't get anything more than that. Minor children can take distributions out carefully based on a structure until they turn 18 in Texas. Some states it may be 21, it's 18 in Texas. Once they turn 18, they have to empty it out in 10 years, right? That rule applies for minor children. It does not apply for minor grandchildren. So many advisors with help your clients and maybe other folks have designated grandchildren. All right? Well, grandchildren are under the pure 10-year rule, okay? So anything other than a minor child, that money has to come out in 10 years, regardless of their affiliation or the relationship with the account owner. And then somebody who is within 10 years of the deceased, age-wise, they get to take it out as a stretch out too. I find that kind of an unusual thing, but it's in the law, and so they get to take it out over their life expectancy. So not a bad deal if you leave it to your brother, your sister, something like that. I think the idea is they're about your age, so it come out just about as fast or as slow as it would for you if you were taking minimum distributions. That's all we have on this. Thanks for listening. If we have clients you can help the Wiewel Law Firm, we'll see them on a complimentary basis at our Austin, Georgetown, Horseshoe Bay, or San Antonio office. Have a great year.